You ready? We're going to call to order the Fire Protection District Board of Appeals meeting for Monday, October 26th, and we will take roll. Board Member Kirby?
Here.
Board Member Semelich?
Yes.
Board Member Sweet?
Here.
And Board Member Klepper. Klepper is absent. And if I can have a motion to elect a chair? The three of you?
Okay, motion to elect chair.
Name who you want as chair.
And really, I think it's just a matter of somebody to kind of shepherd us through the items on the agenda, calling the various items on the agenda. It's not a very onerous job, whoever wants to be the chair.
I'll be the chair. I'll make a motion.
Kirby will make a
Second.
motion. No problem. All in favor, say aye.
Aye.
Great. Board Member Sweet is now chair. Regarding item number 4 on the agenda, the public hearing regarding the consideration for continuance of the appeal, I'd like to run down for you the chain of events that have happened over the past couple of years since the initiation of the appeal itself. On August 19th, 2013, Mr. Friedlander filed an appeal on behalf of his clients. On October 28th, 2013, a hearing was scheduled to consider the jurisdiction. The board decided on a 4-to-1 vote that the board did have jurisdiction to hear the appeal. On February 3rd, 2014, a hearing was scheduled. Mr. Friedlander requested a continuance. The Fire Protection District concurred with that. April 7th, 2014, another hearing was scheduled. The Fire Protection District requested a continuance. Mr. Friedlander concurred with that. On June 2nd, 2014, another hearing was scheduled. Mr. Friedlander requested a continuance. The Fire Protection District concurred. On April 15th, 2015, the clerk of the board sent notice to both parties giving them 30 days to either withdraw or schedule the hearing. On May 14th, 2015, the clerk of the board resent out a notice as Mr. Friedlander did not receive it. Notice gave them until June 5th to either withdraw or schedule a hearing. On June 5th, Mr. Friedlander requested a 90-day continuance. And on September 8th, Mr. Friedlander requested a continuance, and the clerk of the board scheduled this hearing before you today. The only matter before you is what to do with the continuance. Prior to receiving testimony on this, I'd like to swear in any witnesses that intend to testify. Those of you planning to testify, please rise.
Planning on it if I have. Yeah.
You might as well.
Yeah. I was going to ask Dan Clement to testify on behalf of the planning department.
And so if you'll rise too, raise your right hand. Repeat. You do solemnly affirm that the testimony you're about to give in the matter now pending before this board will be the truth, the whole truth, and nothing but the truth? Great. It's the board's privilege, pleasure to hear testimony.
Well, and if I may, Madam Chair, I think probably because it's the motion of the applicant to ask for the continuance, the applicant should probably speak first, and then you would allow Fire the opportunity to respond.
Okay.
Good morning. My name's Dan Friedlander. As you know, I represent the applicant or appellant, Danny Everett and Tiarza Taylor. Thank you for your time this morning. Appreciate you coming out. I think we're getting close to the point where we're either going to decide to dismiss the appeal altogether or move forward with the hearing. I think if we were to set the hearing 120 days out on the actual appeal, we'll know by that time where we're going, and we'll be prepared to move forward if we are going to move forward that time. So 4 months or so, I think would be a good period of time for us in terms of moving forward and having the appeal heard or dismissed.
So then I think if any of the board members have any questions for the applicant based on his presentation, they can ask those questions now. If not, then probably the Fire Protection District can respond.
I have a question. It's been, what, 2 years?
Maybe a little over 2 years, yeah.
So what is it that you need to take in consideration you haven't been able to take in consideration in the last 2 years? Why do you need another 120 days? What's behind this? What's happening?
Over the past couple of years, we've been working through the issues, how we can comply with the fire standards and the county standards for the conditional use permit. And we've been working with our planning consultants, moving along, trying to get to a certain point. It's a long process, and it's a complicated process, and we don't want to move forward with an appeal if it's going to be unnecessary, but it's been taking a long time to get to that point. So I think we're at the final stages of deciding where we're going to go with this, and rather than waste everyone's resources and have a hearing, we wanted to get to the point where we're comfortable with the decision to either dismiss it or move forward with further applications to the county on the project and those issues. So I think it's just a consequence of the land use process taking a long time, and we're trying to figure out where the client wants to go forward with this project.
Has it been a financial consideration they haven't been able to do this in the last 2 years?
There's certainly financial issues involved, but I think it's more of a land use and processing, those issues that are involved rather than financial issues.
That's all the questions I have.
No, I'm
So I think if I understand the applicant correctly, the issue that's framed is a continuance for 120 days to actually set a hearing date. So that would put us, what, into November, December, January, sometime in February, I would imagine. That's what's being proposed by the applicant, to set a hearing date in 120 days. And now I suggest that the Fire Protection District be allowed to respond.
Good morning. I believe we have been trying to work a solution for the past couple of years. We have come to a point that the applicant actually hired a consultant trying to find ways to resolve the issue. But still, I haven't heard anything really in the past probably 8 months or so that where we are with that process. So yes, there has been some work being done. I'm not so sure exactly what else needs to be done. We have provided the conditions or the recommendations a while ago and 2 years ago, and we are still continuing with those recommendations. Perhaps Planning Department Dan can shed a little light on exactly where we are with the planning, what the applicant is planning to do to be able to satisfy fire's requirements. If you don't mind, Dan, I would like to ask you to kind of talk a little bit about where we are with the process with the planning.
Sure. Good morning. For the record, my name is Dan Clement, representing the Resource Management Agency Planning Division. So the last correspondence I had with the applicants or appellants was on March 18th, and that was following a meeting I had with Danny Everett, Ginger Anderson from Penfield and Smith, who's the land use agent representing Mr. Everett. And then on March 17th, we met and they discussed with me their idea for constructing what would be called a shelter in place, basically a structure which could withstand a fire event pursuant to the Fire Protection District standards, such that if the CUP was approved, that is the conditional use permit, CUP was approved to allow the wedding events to occur, that people who attended these events would have somewhere where they could go hunker down until the fire passes through, and then they could evacuate. The problem with that, though, is that these types of conditional use permits for temporary events, they're supposed to be outdoor temporary events. That is, you're not supposed to be building any permanent structures or buildings primarily for the purpose of facilitating these events. We've allowed limited exceptions to that. So for example, like let's say your property's already developed with a single-family residence and you have like a second dwelling unit or some sort of detached accessory structure, we will allow like a wedding party to use that building, but we're pretty adamant you cannot use a permanent building or structure primarily for the purpose, once again, of facilitating these events. And we get a lot of inquiries about this, and we've held the line because if you read the zoning ordinance with regard to these types of events, there's actually very limited guidance on any sort of development standards. We've come up with those over the years. And the Board of Supervisors, when they allowed for these events to occur on properties, they basically said there's two conditions. They got to be outdoor events, and you can have no more than 60 of these per calendar year. So given that, we've held the line. We said no permanent buildings or structures. So at the meeting on the 17th, they discussed what they were envisioning. They stated they need a lot of storage space for their family because they got a large family, a lot of stuff to store. And by the way, they would also construct this building to facilitate a shelter in place. So given that this would be a precedent-setting case, we've never allowed this before, I went back and presented their ideas to the planning division managers along with the planning director. And we responded on March 18th. I sent an email to Ginger Anderson, Mr. Everett, and Mr. Friedlander was copied on it. And we basically told them, okay, if you want to proceed with this idea, this is what you're going to have to do. You would have to withdraw your appeals associated with the current application because this would be an entirely new project description. We'd have to go back to the Planning Commission to have them consider that. As of now, based upon what little we know about what they're envisioning, Planning Division staff would most likely be recommending denial of that project description, once again, because we have never supported the construction of a permanent building or structure for these types of temporary events. We also told them that another option, they could go ahead and apply for an amendment to the zoning ordinance to allow these sorts of buildings for temporary events. That's a pretty elaborate legislative process. They would have to, once again, withdraw their application for their current project that's before you, and then it's on appeal to the Board of Supervisors. And they would have to submit an application for the amendment. And then we said, obviously, they could just withdraw all their appeals and walk away at this point, not proceed with the zone text amendment or this project that they're considering with regard to a permanent building or shelter in place. So that's the last correspondence I've had with them. Mr. Everett, he did respond to me just verbally stating that he's still interested in pursuing the shelter in place despite the risks and the likelihood of a recommendation of denial from us as planning staff. But that's the last I've heard on it. So if you have any questions, I'd be more than happy to answer those.
I do.
Yes, sir.
So if they lose this appeal, can they still do the other process by amending the code?
Yeah, so they have a couple of options. So let's assume that they lost the appeal with the Fire Appeals Board. They still have a separate appeal unrelated to what you are handling with regard to their CUP application, and that's pending before the Board of Supervisors. So they could still pursue that, but they could also, alternatively, they could pursue a zone text amendment to allow what they're considering at this point in time and drop all of the current appeals both before you and before the Board of Supervisors, or see how they fare with you, see how they fare with the Board of Supervisors. If they don't come out on top, then they would then have the option of going ahead and submitting an application to amend the ordinance as well. So they got a bunch of different avenues they could take to get to where they want to end up being. So.
I have a question for the fire department. So nothing's really changed materially since we heard the case 2 years or 2.5 years ago, as far as they wanted access down this road to have these events, and the fire department was against it because if there was a fire, there's no way to protect the people. That really hasn't changed.
Well, almost hasn't changed, because what we had problem before with this event was we had the events at the end of a one-way in, one-way out road, and especially being located in the fire hazard zone, high fire hazard zone, we were concerned in case of emergency we were not able to pull everybody out with the number of people at this event. What has changed, we have accepted having a shelter in place, having a way, having a structure built in such a way that we could shelter temporarily people in place if we have to, and evacuate later.
Just like in a
lieu-
building refuge area.
That's correct. And in lieu of a secondary access. What has happened is that the problem is that with the planning, they cannot build a structure on a CUP, as a part of a CUP application, because this is a temporary, they're building a permanent structure to get a CUP, and that's what is the problem with going back with the planning, and planning is going to recommend denial of it. So they are at the junction that they have to kind of decide whether they want to move forward or not, because they could go through the hearing and get denied with the planning, and that's their option. But as far as this board is concerned, is extending it for another 120 days, I'm not so sure what's going to come back to you, what exactly is going to come back from today or 128 days from now. So that's the part I'm not quite sure from the applicant, what will be the difference from today and 120 days from now.
And I really think it's good to have that background, but the board should remember the narrow question in front of you is simply whether or not to continue this for 120 days. I was a little worried that we were getting into the substance of the actual case itself, but I think it is good to have a flavor for it, but that's the question before you right now.
Well, it has been quite a while.
Right.
So we have, I asked Brian for some information to help with my memory, which he couldn't provide, so.
I'm sorry, did you have another question? I think I might have started speaking when you were,
No, I think I was getting beyond it.
If I may add one thing for the board to consider. If we make the decision to proceed with the actual hearing on the merits, I would assume that the board would like some briefing beforehand so that everything is not new to the board on the day that we come in for the hearing. So in the 120-day time frame, maybe we would suggest that 30 days before the hearing, we would have some written materials to you, should we decide to move forward, outlining our arguments, and then the board would be more educated on some of these issues when we come in. So that's why I think 120 days is probably the shortest period of time to really get everyone up to speed on things. And if we didn't go any shorter than 120 days, we're probably in the holiday period. So I tried to make it as brief as possible in terms of timeframes for moving forward.
120 days is after the holiday period.
Right. If we were to get you some briefing, if I'm to get you briefing 30 days before the hearing, we're probably right in the middle of the holiday period. I think anything sooner than that, a 90-day hearing would fall right in the holiday period. So that's why I'm suggesting we do it after the first of the year.
Are you proposing that if you don't have a hearing one way or the other, you don't notify the board or the fire department that there's not another hearing to hear this again, that it's over? Are you willing to stipulate that?
What I propose is that we set the hearing. We're not going to ask for another continuance, and we'll notify the board beforehand whether we withdraw our appeal or we're going to move forward with the hearing date that the board sets.
But it won't be extended any longer?
We're not going to request a further continuance.
Okay, no, I don't have any more questions.
Did you have any?
No, I'm okay.
Okay.
so then I think you should, the matter before the board is whether or not to schedule this hearing in approximately 120 days. And the board could add to it what Mr. Friedlander suggested, and that is any type of pre-hearing briefing be due 30 days before whenever the hearing is scheduled.
Can we also stipulate too that a further continuance isn't going to be acceptable?
Right. I think you could. I think you could also, in that motion, add that no further continuances, absent extraordinary circumstances, will be considered.
Okay.
Something like that.
Okay. So do we proceed then with,
Probably need to talk.
Yeah, you can discuss it right here amongst yourselves on what the three of you think. And then when you're And Brian, you can jump in too if you want, but I think you discuss what's in front of the board amongst yourselves on the record, and then when you reach a point when you want to vote, then you vote on whether you should approve the request or not.
Okay. So do we do this privately on mic, or how do we do this?
I
on
think he
record?
said right
Okay.
here.
Okay.
What's your feeling on it?
I think that's 120 days is quite a long time.
Yes.
They've already had they've
Mhm.
had years.
And there doesn't appear to be any change. So I'm of the opinion of not continuing.
I agree.
I agree also, but I hate to take somebody's due process away. I don't think this is going anywhere. I think I think if he has a hearing with the fire department and the fire department approves the refuge shelter, they can't really proceed because the planning department, they have to issue a permit for that. So it's kind of messed up.
Sometimes you just can't do what you want to do, though.
Yeah. I concur.
And if, I know I'm not a voting member of the board, nor do I want to be, but the alternative then, what's the alternative? I mean, would you order a hearing in 30 days? I guess that also should play into what's the...
Is there an alternative? It's not just a yes or a no? He's proposing 120 days.
He's proposing 120 days to set a hearing itself. We have no other hearing date, so I think then the alternative would be to figure out another hearing date that is less than 120 days. I mean, I think that's in essence what is going on here. It sounds like the board, what the members are saying is that there have been so many continuances so far, you think enough is enough, and you need to have the hearing. So, and 120 days is too long, but then what's the alternative? You're going to have, say, we're going to have this hearing next week, we're going to have this hearing in a month. You have to factor that in and give each party appropriate time, kind of what he was saying, to let them prepare so the due process rights aren't infringed upon, so they could prepare a hearing.
Okay, so I have maybe a suggestion for us to consider. They have had 2 years or 2.5 years, and it just seems like this is too long of a deal. Can you hear me? Seems like this has gone on too long, and I agree with that. So if you're going to have a hearing, they should set the hearing date now, and the 30 days before now, we should shorten it up so it either happens or it doesn't happen. Can we do that?
You could, but one thing that just occurred to me, I don't know.
That would be an alternative than just saying no more continuances.
Right, and I don't know if we ever heard Fire's position on the proposal. I don't know if Fire, because that's another factor, and I've represented a lot of boards and commissions, but I'm not sure if Fire agrees with the proposal or disagrees with the applicant's request.
Oh, yeah, I see.
Good point.
Let me kind of answer it this way. Since the board has decided to hear the case, then there is no other option but hearing the case. I'm assuming that would be the case. That I don't have any objections with extending it 120 days in that regard. I just wasn't sure exactly what will become of it, what will be presented. I don't have any objection with 120 days in that, with their request. My question was, I'm not so sure whether it will change anything from today or 120 days. But if that's not the question, then I don't have any objection to the continuance.
So it sounds like Fire is not opposed to a 120-day timeframe, and that would be the last, basically, drop-dead date. I mean, there are no more continuances. In 120 days, the hearing would occur. And I think Mr. Friedlander's suggestion, whenever the hearing is a good one, to have pre-hearing briefing to kind of crystallize the issues, because this is kind of up in the air. And I know from other experience, and we can even borrow, I think, from the Civil Service Commission, they have rules on pre-hearing briefing to lay out what the issues are, what kind of evidence is going to be presented, that type of thing, to give this board a preview of what's going to happen at the hearing, to also help the parties narrow their focus on what to present at the hearing. It just kind of helps. So whatever date is chosen, sounds like the parties are aligned at 120 days, but whatever date this board chooses, I think personally it is a good idea to have that extra, that any pre-hearing briefing will be scheduled 30 days before. And Mr. Palmer and I can work with the parties too, and kind of making it clear what that pre-hearing briefing could look like.
So this is, you're requesting a continuance of the appeal. Was there a expiration? Is there an expiration of the appeal?
Like a timeframe in which it has to be heard?
Mhm.
No.
Okay.
It's interesting, the Fire Appeals Board rules are pretty wide open. Actually, there are no rules. It just basically says, there shall be a Fire Appeals Board. The Board of Directors of the Fire Protection District, which is the County Board of Supervisors, appoints the members, and that's kind of it. And you hear fire appeals. So there aren't any statute of limitations, any time frames, really any rules on how to conduct hearings. So we kind of wing it and borrow from other boards and commissions and based on other practices and customs. So that's what we're doing. So I think, and Fire could correct me if I'm wrong, but I don't think that there is any expiration or date, any statute of limitations.
But we can make that determination here as the board.
I think the board has the inherent authority to conduct hearings in a timely, efficient fashion, but also keeping in mind the parties and the complicated issues that are involved and so forth. You know, so you can kind of frame and schedule hearings as you deem fit, with a nod towards the parties that, in essence, this is their case. You know, that they have a good idea of how these things should proceed, and the board should too. But at some point, you know, you set a date, and that's it. No more continuances. We've given you some leeway, and I think even Mr. Friedlander is proposing, or he even said, no more continuances. Whatever date you set and he proposes, and Fire is okay with it, 120 days out, that'll be it. So either we'll have the hearing or they'll withdraw, and we'll be done.
Is that true?
That's correct. We will not request another continuance.
So it's either going to be 120 days from now, or we won't meet again on this issue.
Correct.
So if we opt to extend it 120 days, and how would the briefing, how would we do a,
We'll
how
be
would we get
notified
some?
probably.
I know, but would it be here? Would it be an email? How would we get?
It would be in writing,
additional information?
probably submitted to the clerk of the board, who then will
It's like a
distribute it.
packet?
Yeah, exactly.
Okay, for review.
Yeah.
Okay.
And Mr. Palmer and I can work with the parties on what that'll look like. I know in other arenas, it's usually something short and sweet, just a few areas that they touch upon. It's maybe, I can't remember with the Civil Service Commission, Brian, but, you know, maybe like 4 or 5 pages, something like that, just to, like I said before, narrow the focus of the hearing and get the parties to kind of concentrate on what is going to be presented at the hearing itself, and it gives you a sneak preview of what you're going to see. So then when we have the hearing itself, it's not so wide open and, you know, freewheeling.
Well, if I remember correctly, you were going to put on a presentation with slideshows and pictures.
Yes.
So it would be a package that gave us the written points from probably both sides, and it would be some photographs and pictures representing what the area looks like.
Yeah, I can imagine photographs, aerial photographs, photographs of the site, slides with prior documents that have been submitted or considered.
You're not suggesting field trips?
No.
Okay. Okay.
And when would we have, so I guess we have to decide on if if we do the continuance first, and then when we would
Yeah, but I
request the
think
package.
this is where I got confused. It was either, I thought this was either yes or no, it dies here, or we let it go another 120 days. And it
Well,
dies.
correct.
It is interesting, and it's a little awkward because we're talking about a continuance, but there was no prior hearing date. Like, today was not a hearing date where he would present his case and there'd be witnesses and so forth. So it's more or less a scheduling type of thing, and this board hasn't met in 2 years. Mr. Palmer and I have kind of been working behind the scenes with the parties on these various continuances, but at some point, we decided we should probably let the board give some direction on how, on what it wants to do. So right now, this is really a scheduling hearing, because I don't think this board would have the power right now just to say, nope, dismissed, we're done with it. I don't think that's the case, because it's still up in the air. So it's really setting a date for a hearing, and it's up to the board to determine that. Sounds like the parties are both okay with 120 days. So I think that's really what the proposal is right now before this board, whether to grant the request that's not opposed by fire from the applicant for a hearing in approximately 120 days. And it sounds like the board is interested in this little add-on of any pre-hearing briefing to be submitted to the clerk of the board 30 days before that hearing date.
Okay. So now we have to decide.
I think we decided, and now we're redeciding. I think we go along with the 120, my opinion is we go along with the 120 days. I think we have to. And we say 30 days before, or earlier than 30 days before, 45 days before. Anything that they want to do before the 30 days so that the presenting of the evidence doesn't delay the 120 days. 120 days has to be a drop dead date.
Yeah.
That's it.
Yeah.
So can't say, well, we can't have the hearing because we didn't get you the evidence because we weren't ready. Either get it to us 60 days before, 45 days before, 30 days before, but if they don't get the evidence to us at the 30 days before, there's no hearing. Or they
Well,
have the
and
hearing
can I
without
clarify?
the evidence.
I don't think what's being proposed is that the actual evidence will be submitted to you 30 days before. It is more of a written brief outlining the issues and what is to be presented to
Is
the
that
board.
true?
That's true.
Yeah.
I'm suggesting a written brief apprising the board of the issues that are going to be involved, and maybe some background information be provided to you beforehand. But the hearing, we propose that we just do the standard hearing. We submit our evidence, and we present our evidence at the hearing itself.
I get it. I just
Yeah.
don't want the brief, or whatever you want to call it, delaying the hearing.
I can't see why it would.
Well, the applicant could say, well, we didn't get you the stuff because we weren't ready, so we need another 15 days or something, and keep pushing it out.
We'll commit to not doing that. We'll commit to
Okay.
having you your materials.
And I think what should happen is what happens in other arenas, that both sides simultaneously, 30 days before the hearing, submit just I know in the law, a brief is often a misnomer, but literally a brief, 4 or 5 pages outlining certain key issues, just to give you, it's almost like a teaser of what you're going to see 30 days later.
Well, it's just, it helps you with foundationally to understand what the case is about.
Exactly,
So-
just to give you a background on the case, what you can kind of expect the issues to be. And then when the hearing comes, that's when the slideshow will be presented, any other exhibits, any witnesses by both sides.
Okay.
Yeah, then if, I think as long as it doesn't go over the 120, I'd be okay with that.
Okay, I agree. So agree to
Make them schedule it now.
yes.
Yeah.
So let's schedule,
Who wants to make the motion?
I'll make the motion.
Board Member
Seconded.
Kirby, seconded by Summelich. And it is to approve the continuance for 120 days, direct both parties to prepare briefs and submit to the clerk of the board 30 days prior to the scheduled hearing date, and deny any further continuances.
Correct.
Yes.
All in favor, say aye.
aye.
All opposed? None. It's unanimous.
Mr. Palmer, if I may ask, is there a particular day of the week that the board meets, or should we be talking about dates today? Or?
Yes, so I don't know if you want to discuss actual dates, but 120 days, the The meeting room would be available February 23rd, or after that would be March the 7th or the 21st. Does the board wish to set the date today?
I think so, yes.
May I add, Mr. Palmer, I'm in trial on March 7th, but the other 2 days
I think the sooner.
are available for me.
What day of the week is the 23rd?
They're all Mondays now.
Okay,
So
February 23rd, I propose.
I agree.
I agree.
Does that work for fire?
I'm,
Checking the schedule.
oh, wait,
Yeah.
I have to check something.
Was it February 23rd?
yes,
And that's a Tuesday?
That is,
Monday.
And Monday.
it appears to be on Tuesday.
Tuesday.
That's why it's confusing me.
Oh,
Oh,
they're saying that's a Tuesday.
23rd is
According to
Tuesday.
2016. February 23rd.
Brian, I have to check my schedule. There's some period I'm out of town.
Mr. Palmer, are you sure the February 23rd is on Monday? Because,
No, it's,
oh,
Yeah.
22nd is Monday,
Oh.
that's right.
yeah.
That's what I was wondering.
You're right, they put 23, 23.
Yeah,
You're absolutely right. It would be February 22nd.
that's correct. Fire is okay with that.
Okay, 23rd's good for me.
22nd.
22nd, Monday the
22nd.
22nd.
Monday the 22nd. My calendar has two 23s.
And that, Mr. Palmer, would be at 9 a.m. here.
Yes, correct. Is that all agreed at this point?
Yes.
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 Fantastic.
So that will be, just to clarify, that'll be the hearing date,
Yes,
or we'll receive a request to withdraw prior to, from the applicant, correct?
Correct, yes.
Okay.
And 30 days prior, we'll get the brief?
yes.
I think the hearing will go whether we get the brief or not on that day.
Yeah.
Right. And that is a good point. It's really optional. I think if the parties wish to present a brief, it's up to them, but generally, that's what happens.
So again, the brief is going to be optional. You
That's
guys
fine
okay with
us,
that? Are you all right with that? If they don't decide to do
Yeah,
a
it's to
brief?
their benefit to provide briefs.
Mhm.
Yeah.
Yeah. Okay.
Am I correct to assume that if the applicant is going to withdraw, that will be well before the 30 days before the hearing?
We can set, that we would agree to either submit our brief 30 days before the hearing or a notice of withdrawal 30 days before the hearing.
That sounds
That's better.
perfect.
Yeah.
That's good.
Mhm.
Yeah.
Mhm.
That's what I just want to clarify. Thank you.
Continuing on your agenda, ma'am, you have public comments, for which I don't believe anybody is here to speak. And on your agenda, you also have board comments where you can each make a brief statement if you like, or you may adjourn.
I recommend adjourning.
Second,
Yeah.
they need the parking spaces out there.
That's right, parking's at a premium now.
Yeah.